the two other pages. If it is something that's important to me, I'd like to speak from, if it's possible, from a point of knowledge and not having any background on it. That being said, I'd like to talk for a few moments on number 4, the continuation of the public hearing. As you know, except for the last 2 months that I've missed, I've been attending all the meetings, and I thank you now for the last couple of times putting on the agenda that it's going to be adjourned. That saves some decision making. But on that topic, I'd like to know why there have been a minimum of 2 unadvertised, what I would call illegal meetings concerning that project. One of them specifically was attended by, of course, the village board members, the landowner's attorney, Mr. Bannock's attorney, and all his professionals. And apparently, and rightly so, the village board must have had some questions for them. But wouldn't you thought it be appropriate that the public be invited? It was neither on your calendar, it was not advertised in the newspaper, and if that's not illegal, I'm not sure what is, but the meeting took place. It appears that, at least for one of the meetings, the topic was not so much about the zone change, but instead, in my opinion, the questions and discussion concerned the domain of the planning board. It was more of a site plan. So it seems to me, correct me if I'm wrong, that this is not just a new zone, but a zone being made and tailor-made for a specific property. At this point, I'm referring to it as the Bannock. I forget what it's on the agenda as. No, it isn't given a name on the agenda. The Bannock application of the shopping center on Schoolhouse Road. So, if the village board is going to entertain the applicant, all his professionals and everybody else, and then talk about things like setbacks to adjust the law for him, the potential law, or parking, or any other things that are site plan specific for the planning board, I believe it's inappropriate, correct me if I'm wrong, and I believe also I should have been given the opportunity to have attended and heard your knowledgeable questions. To add insult to injury, that this law seems to be made, new zone change is being made for a specific property, specific development. It's also being made for a specific property owned by one specific individual who has had that property, except for the 2 years that I managed when I was your code enforcement officer, to have him put back on the tax rolls. It's been virtually tax exempt. And it was tax exempt for something called an agricultural use, which is, as you know, is not a permitted use in the LO zone. It's taken off as a horse boarding facility, which, as you know, it is not, even if it was permitted. So, if you can answer some of those questions, there's a couple of whys, and if you agree. And again, as I said the last 2 months ago when I was here, if there are any meetings, or when this comes up, or when the final environmental study is done, I'd like a little bit of a heads up, so if I have any complaints, I'd like to have an opportunity to speak from a point of knowledge. Mr. Mayor?
Would you like me to start?
Sure, you can start now.
First of all, there are two things being considered by the board. One is a site-specific zone change that is related only to that site. The other is the local law that is being adjourned tonight and has been for many months, which is a general local law establishing the new zone. that if the zone change is granted, that law will be applied to this property, but it will also be applicable to other properties. So the local law is a general law. The zone change is site-specific. Okay. Secondly,
I wanted to say, okay, I'm confused. The zone change is site-specific.
yes, there is an application before the board, two separate applications. One is for a petition for a zone change for those 4 properties on the west side
Okay.
of Red Schoolhouse Road. The other issue that is before the board is the local law establishing the zone known as the RS zone, regional shopping, which we don't have at the present time.
Which one of those then is number 4?
Number 4 is the proposed local law establishing the new zone.
That would apply to anybody who wanted.
That would apply to anybody,
And
to other, not to anybody, but to other appropriate properties.
okay, and then where on the agenda was the other one you stated? You said there were 2.
Yeah, the
I'm sorry,
petition.
I'm not playing dumb.
No, I understand, it's complicated. The petition for the zone change was part of the public hearing, but it is a separate application.
Is
The
that
board-
part of the draft, the environmental study then? Is that-
The environmental study, yes,
Okay,
is being done for both. So no decisions have been made on the environmental study, on the zone change, or on the local law as
Okay.
yet.
all right.
The meetings that have been held with, the one meeting that was held with the applicants, the only meeting that was held, I was told by the office, had been sent to the Journal News, notice of that hearing, of that meeting. It was a public meeting. It was, I believe, also on the website.
It wasn't. I'm sorry, just letting you know. it
I don't
wasn't.
look at the website, I was told it was on the website. One of the problems with having things advertised, having meetings advertised in the Journal News is if they're not public hearings, we pay for public hearings. Those must be put in the paper by the Journal News. All other meetings that are not public hearings, like this meeting tonight, is sent to the Journal News to be in their community section, correct?
Community news.
Community news. All of these workshops are sent to them by the office to be on the community news, in the community news column.
Is that the same as legal
We are
notice?
not required, if they don't print it, we have no control over it. All we can do is send it to them.
Shouldn't there be a legal notice if not community news?
No, we don't pay for paid advertisements for anything but public hearings.
Is a workshop a public meeting?
It is a public meeting, it's not a public hearing.
Getting
That's how
past
it works,
Everything
all
that you
right?
said, even if I agree
I
with you,
don't-
I've left my email, my phone number, and I've asked on the record to be notified. I would have liked, even if I couldn't speak at the meeting,
They were in the nature of workshops, yes. You
I
been
would have
permitted-
sat there.
Certainly, it was an open meeting, you could have attended, probably workshops, the public does not speak, but they were open meetings. And
But I
they
didn't
were
know about
sent,
it.
unfortunate, but they were sent to the Journal News, and I have been told they were also on the website.
Well, What about the second meeting, on or about, I think it was September 6th? You had a workshop. The applicant wasn't there. I don't know if it was a last minute, he didn't show up or whatever.
No, he was not invited.
Okay, but that one also was neither in the newspaper, or on the website, or on your office calendar, which I get every month.
That was a meeting that was, I think, scheduled just a few days in advance. I am again told it was on the website, and it was not, it was emailed to the Journal News, but they did not put it in the paper because they claimed they didn't have enough notice.
Not that, and I thank you for your answers, not that the rest of the community doesn't deserve notification, but at this point, let me again try to make it clear. If there are any discussions that I'm legally allowed to attend, whatever they're called, public, private, workshops, hearings, whatever, on this either zone change or specific development, I ask you please for the courtesy to, Florence has my phone number, my email, I don't know, whatever else you know about me. If you, please just let me know. Thank you. Oh, you said she was gonna start, does anyone have any
I
answers?
just wanted to say, I asked the same thing. When we had the meetings, I asked Florence very specifically if she sent the notices to the Journal News. And she assured me that she did send the notices, and that when she saw it wasn't in the Journal News, they said they didn't have enough time. And sometimes these meetings, when you have one meeting and things are left open and you have to discuss them, the availability of our consultants, or the availability of the board with our consultants might be the next week. It might not be 2 or 3 weeks that we have to hold it over, so that the Journal News feels comfortable about putting it in.
I have no problem with that, I can understand the logistics of that. But there had to be some forethought here for all of, or so many of the applicants, professionals, to have shown up. So I'm not gonna beat a dead horse. I think I made my point, and I'd just like to be included.
We'll make sure that it's on the website.
Okay, and the resolutions, if possible, just.
I would think that the resolutions depend upon the agenda, and sometimes the resolutions are 11, 12 pages.
And sometimes they're not ready until the last day.
Well, I remember in Rampo, when we used to go up to speak, they told us, including you, Mr. Mayor, we don't know what we're talking about. And our answer generally was, we had no idea what we were talking about because we only just heard about that something was happening.
But that didn't stop us from
That
talking.
didn't stop us from talking, but they still had that argument, we said a lot of wrong things, so I just like not to repeat that, all right, thank you.
Anyone else? If not,
Yes. I didn't have a question before. I didn't have a question before, but now I do. Mark Levine, 14 Lancaster Lane, Chestnut Ridge, New York. Just for clarification, your September 6th meeting was put on the website, the date of the meeting. The August 28th meeting wasn't on the website, wasn't in the Journal News, and really wasn't appropriate under the open meetings law. If you're gonna put it on the website, I think it would be appropriate not to put it on the day of the meeting. It should be put on in advance.
Lise
I know
was
that
away.
Lise wasn't available,
Right.
and there was a reason. Usually, when you're a group, a quorum is meeting. If you can't advertise it, can't meet. That's enough of that issue. My other question, after Mr. Mitzner was discussing these meetings with you, how many public hearings are you involved in? I was under the impression that your board was involved with one public hearing for a new zone.
Yeah.
But what I'm confused with, or what I believe I just heard, is that you're in a public hearing to establish a new zone and the guidelines for a new zone. And it sounded like you're also in a public hearing for a zone change for 3 or 4 different parcels of land on Schoolhouse Road.
Yeah.
So that's 2 yeses, but that should be 2 separate public hearings.
There was one public hearing held for the Sika and the zone change. The local law is a separate public hearing. That one was closed, if you remember, many months ago.
The public hearing,
Right.
because I'm not even sure if the board understands. Do you?
Yes, we do.
Oh, and please explain it.
We have to have 2 separate
The
public
hearings, yes. So
Right.
one of them was closed.
Yes, the one on the zone change has already been closed.
The one on the zone change for the specific
Right,
parcels
and
of
for
property?
the parcel of property and the Sika public hearing. That's why we're now working on the final environmental impact statement, because the public hearing on that, we got all the public comment, if you remember, over a series of meetings about here, within that one public hearing. And that hearing was closed, and now the board is working on the final environmental impact statement. The draft environmental impact statement was submitted by the applicant, if you recall.
Right.
The public hearing was held on the draft, it was closed, and now these meetings that we're having, these workshops, are to, with our own consultants, are to finalize the environmental impact statement. We couldn't start working on the final environmental impact statement until the public hearing
Okay.
on the draft had been closed.
And
Mark,
every,
if you get the
every-
minutes where it was listed, all of the comments of the public were listed. All the comments were in print that the public had in that public hearing. It's on record.
for the new zone?
For the
Or for the,
All the issues were
for the new
addressed.
zone or for the zone change?
for the zone change. When people got up and some of you complained that Steve complained that the businesses would, suffer. Do you remember that public hearing, Steve?
Don't,
Mark.
you speak.
Mark, the only reason this local law public hearing is still being adjourned is because there is a statutory 62-day window. If we close the public hearing, we only have 62 days, the board only has 62 days in which to make a decision.
Right.
That's why this
I
one is being
No,
continued.
I understand
Doesn't
that.
apply to the zone change. The zone change is a completely different.
Well, once you close the public hearing on the zone change, don't you have a specific time that you have to act on that?
No, because the Sika
Oh, because the seeker's on.
The Sika
Okay.
puts the moratorium on the,
Silly question. How can you be entertaining a zone change on a specific piece of property and have closed the public hearing on it when you have yet to establish the zone?
because the board has not made a decision on the zone change.
Right, but that's,
They can't make a decision on it until
the
the
law is
the
established.
law is established, if it is going to be
Right,
established.
but again, it just doesn't seem right that you're closing a public hearing and you're hearing an application for a zone
Because
change
we have to finish
when you don't even know what the zone is.
because we have to finish the Sika.
Okay, I mean, it seems out of order. But now,
Blatant state law.
but
We
now I
don't have a
thank you
choice.
because I understand what's happening.
We don't have a choice.
When
Thank
we
you.
see the new zone.
Hal Sherman, 8 Pine Hill Court, the Village. Now, I'm confused a little bit. When you had said you are working on the final environmental impact, the board is working on it?
Yep.
Or Vanek is working on it to submit to you for review?
They have already submitted what they consider to be the final. The board, the final environmental impact statement is the board's document, not Vanek's document. Vanek submitted its proposal to the board for consideration. The final environmental impact statement is being prepared by the board and its consultants.
Now, we looked at, and again, I read the environmental impact, the preliminary that they submitted, which was written in 2010 and had many flaws in it. Is the public, including myself, going to be able to review what changes needed to be made? We were waiting for a report from the Corps of Army Engineer. We were waiting for other reports, which they hadn't obtained. They still hadn't talked about or found a remedy to knowing that the property had contaminants on it. They were talking, there was a building with contaminants in that they hadn't even addressed. How are those incorporated into a final impact that you're considering when it's the property owner's responsibility to do that before you make those changes? Those are known entities. We've known about them. They prove them in their documentation. And you're working on a resolve to write a final impact? That's why I said I'm confused. How can you as a board write an impact study?
I think we're getting off the public discussion on agenda items, but very briefly, the final environmental impact statement will address the manner in which those issues will be corrected.
Okay, were those discussed at the August 28th meeting?
The August 28th meeting.
All about
I don't-
concerns
I don't
given to
recall.
the applicant.
Okay.
I don't recall.
Are there minutes
I-
available for
I
that
don't
meeting?
recall if that was specifically discussed.
Okay, are there minutes available for that meeting?
No, they're
No.
not.
Well, you said it was a public hearing and there are no.
No.
No, we didn't.
That it was a public meeting.
Public meeting, and there are no minutes?
It was a workshop
No.
of a public meeting. Workshops, we don't
We don't
prepare
keep-
minutes for
okay.
workshops.
There were many issues discussed
Concerning this,
concerning
I
the
know.
project.
And there's still going to be others because we're not there yet.
We're not satisfied yet.
okay, and who is it on the board, or do we have a consultant
We
that
have,
is,
we have two consultants, engineering consultant, Dennis Rocks, and Bob Jenislaw, our planner, are constantly in touch with the applicant, going back and forth to refine the issues. Then Doris reviews them with us and tells us basically what's outstanding, and then we go back to them.
Well,
and
that Doris doesn't tell us what happened, Bob tells us.
Bob tells us what's outstanding, and then more information comes. If we don't like it, what their their issues are, or their responses, we explain it to them, and then they come back. Nothing's gonna be passed until we're satisfied that everything that was asked for is documented, and so that we can make the final decision.
okay, when is the next workshop concerning this topic?
Joan was just
scheduled?
asking that, we haven't set a date for it.
10 seconds before you go on, really 10 seconds. I mean, if the zone change part of it has been closed, then do you know what the side yards are, the buffers,
That's the law.
That's in the local law.
That's the local law.
Oh,
You have to
okay.
understand.
I'm
when
trying
we're
to.
When we're discussing this, we are discussing, when somebody hears us discussing buffers from a residential and setbacks and all of that stuff, we're discussing it from the point of view of the local law. If this project is to go forward, they have to abide by what we put in our local law, and that's why we're talking about setbacks and buffers and things
All
like
right,
that.
but then,
It's
that's
not
a
like
local
we-
law, but the zone change, like if I were to look up the NS zone in our book,
You would have.
or the PI zone in our book, the zone tells me what the front yard is, the
Absolutely.
setbacks. But that part has been closed, yes?
No,
No.
that's the one that's being
That's the
adjourned.
local law.
The local law establishing the district with all the bulk requirements and the use requirements, that's on
And
the
what does the
agenda
other
tonight.
one, what does the other one decide?
The other
Just
one
whether you have
is-
another zone?
The other one is whether the board will agree to change that property from LO to RS.
Okay. I feel silly as the code enforcement officer in zoning for
This is
25
the
years.
same as any
But
other
I'm lost.
zone that is in our book,
Okay.
the one that's before us.
Mr. Mayor, I'll take a 45-second crack, all right? I'll take a 45-second crack at it. The law and the zone change have to go hand in glove. You could have a law that says we're gonna have A, B, and C. But what got us to say that we want a law to say A, B, and C? Property owner comes and says, look, we want to establish a zone. We want to establish a resident, we want to establish a retail store zone. We believe a retail store zone should be comprised of A, B, C, D, and E. Okay? Based upon that, we would then, if we agree with the confines of that type of zone, we would then draft a law to mirror that zone. We are in the process now of doing that. We are reconciling the zone change, we are discussing whether a zone change such as this should occur. If it should occur, what would be the parameters for such a zone change? Anchor store can't be any less than 45,000 square feet. You can park in the back of the, if you want to have parking in the back of the stores, your employees have to park there. If you want to have a restaurant pad, the pad has to be a minimum square footage, okay? You know what? Okay, that's a zone that could work. So now, we would like to put, so once it's zoned for that, once we figure that the prerequisites for that zone, we can live with, they make sense according to planning, engineering, traffic, and what have you. Now we have to make a law to say that, because we may now have another property similar in size, or that a potential developer will cobble together and do the same thing. And so now they're also gonna have a retail store zone that they can open the book and says, okay, I could have an anchor store that's no less than 45,000 square feet. I could have so much parking, but I could have parking in the back so long as it's for my employees. I could have a restaurant pad so long as the pad is X size. I'm gonna put that right here. You can't do one without the other, in that we're not operating in a vacuum. We just didn't come and say, you know what, we wanna make a law
I got
for
you.
this.
I appreciate
where
it,
we're at.
and I'm gonna
I
give
know
you a
about-
break. You went over the 45 seconds, I may ask for extra later.
I was just gonna say.
But no, thank you. You did make it clear. Thank you very much.
I move we close this public discussion.
Second?
All those in favor?
Aye.
Anyone against? So done. All right, this is a public,
Did we adjourn the
No, we're gonna do that
public
now.
hearing?
I propose that we adjourn the public hearing on the local law, entitled Local Law Number 20 of 1987, to the October
18.
18th,
18th.
October 18th meeting.
Second.
All those in favor?
Aye.
So moved. This is a public hearing on renewal of the franchise agreement with Cablevision. John, Robert, do you want to speak? Or?
Thank you, Mr. Mayor, honorable members of the board. My name is Robert Hott. I'm the Director of Government Affairs for Cablevision. I'm a resident of the city of White Plains. My colleague, John Dullahan, is with me here this evening, and I'm here to speak tonight on the franchise renewal agreement for Cablevision. Our previous agreement expired at the end of 2011, currently operating under temporary operating authority, which is granted to us by the New York Public Service Commission. And over the last few months, this renewal document has been negotiated with Ms. Allman and Mayor Cobre, and very happy to be here tonight to speak in favor of your support. Just very briefly on the highlights, the agreement is substantially in the same format as the previous agreement. The franchise lasts for a term of 10 years, and the agreement becomes effective upon its confirmation by the New York Public Service Commission. The service area covered is the entire incorporated village. Our hybrid fiber system is completely built at this time, so there's no major construction required as a result of the renewal. Among some other facets of the agreement, we are going to be providing 8 free cable drops to specific municipal buildings and schools in the East Ramapo School District. The agreement provides that Cablevision pay the village a franchise fee of 5% of our gross receipts earned in the village, and that is paid quarterly. That's money that goes to your general fund. It doesn't have to be dedicated to anything cable related. And then finally, the franchise contains a unique provision continued from our prior agreement requiring Cablevision to give the village 10 days prior notice of any non-emergency tree trimming. It requires Cablevision to comply with any changes in proposed trimming work that the village requests. And it also requires that all branches and other vegetation be removed within 3 days from the trimming site. Just so you know, we normally don't do regular trimming since we don't own the poles. We lease pole space from either Verizon or O&R. So when 99.9% of the time when we actually have to do tree work, it's an emergency situation. Thank you again for the opportunity to speak tonight. I ask for your support, and if you have any questions, I'm happy to answer them at this time.
The current contract, when was that established?
It was authorized by the village in 2000. At the end of 2000, I believe it was confirmed, I want to say it was October of 2001, because it expired in October of 2011.
So it was a 10-year
It was
contract?
a 10-year contract.
Time flies.
Some communities have started doing 15-year agreements. That's the maximum you can go to in New York State. So there are some longer agreements, but we agreed upon the same time frame.
In the original one, I remember that there was a build-out period of time for the entire village to be covered and to be able to receive your, yeah.
Yeah, there's no build-out required at this time. There's a minimum
Everybody in the
density.
village now has the opportunity to be part of
Correct.
cable.
Correct. And businesses as well, if they, unless there's something non-standard or some required contribution cost, all the businesses in the community as well should be able to receive that.
Thank you.
I have a question, Mr. Mayor, if I may. Mr. Hawk, I know we can't, we have to be fair with all of the providers. What we ask for from you, we ask the same thing from Verizon, whatever the case may be. My concern or my question has to do with, at one time, I believe cable providers were doing, and now they stopped, with regard to some type of reduced service fee for senior citizens in the village. I see in this in here that it's not provided for because we can't make you provide it. And now my question becomes more of an observation. I would think from a competition or from a marketing standpoint, and especially in the days where people are on fixed incomes, they're having problems with their either telephone, TV, computer provider, that I would think that Cablevision, at least for the seniors, would say, you know what, we'll offer you basic cable service, and you're gonna pay whatever it is, a minimum amount. And I would take a guess. Now, you're the government guy, affairs guy, so you know your marketing, you know your demographics better than I'm sure. But I would think that in these days where people will switch a provider for 10 cents, that if you got out there to at least the senior community, to say, look, we will provide this basic service for you at a reduced cost, I would think you'll have people jumping at the opportunity. Am I kind of off base? And I won't be offended if you say, look, that's like yesterday's news, nobody does that anymore, but.
Well, no, I mean, you're right, it is an extremely competitive environment. I mean, we're probably in the most competitive area for video services. I mean, not just us and Verizon, but there's still satellite customers, and you can still, if you have a digital antenna, you can still get broadcast. So you're right, it is an extremely competitive area. As far as a franchise obligation in the document, which is really what I can speak to, is it comes from a competitive neutrality standpoint. I don't believe there was a requirement for senior discount in the prior agreement. I know Verizon would not agree to it, which is a big reason why, policy-wise, we don't agree to them going forward. My understanding in the past is they've never been huge discounts. The traditional one was something that was like 10% off broadcast basic standalone and didn't apply to anything else. We offer a lot of different services now. We feel there's a lot of value that we provide in introductory offers. There's a lot of pressure on us to keep customers, especially because of the competition. So I think, you know, with retention and introduction, there's a lot more value than what was in a lot of the senior, compared to the senior discount. However, we do still offer the basic packages. It's still quite a bit less than all the other, you know, high-level packages. And also part of my job is conveying, you know, your position on it up to the company. So I'm very happy to, you know, to convey that that's a position of your board, and we'd like to see that.
I think there was some confusion when it came to having to get boxes for sets that didn't have them. The impression was you would not get a picture, right? Turns out that's not true if you have a flat screen TV, but you won't get all the channels, but you'll still get what you're getting now.
There are certain televisions that the newer television has a tuner that's called a QAM tuner. If you're a basic subscriber, basic channels are unencrypted. I know there's a lot of confusion about what's digital and what's analog and what's not. When we're all digital, the basic tier will still be unencrypted, which means if you have a television with a QAM tuner, you can still, you know, plug the cable right in and it'll still work. Because the boxes are free for a period of time, and for analog only customers, I think it was a 2-year offer. For people who had absolutely no boxes in their house at all, I think it's a 2-year offer. We encourage people to take the equipment just because of, you know, the value of what they're going to be getting as a result of having it.
I think the fact that you gave the first year free got everybody to take it, it says. You know, not thinking that they didn't have it. If they didn't, they were going to lose this reception altogether. But that's not the case. So, okay, I got the boxes. Anybody else? Anybody want to say anything? If not, thank you very much. Thank you very much.
I move that we close the public hearing.
Right. Did we hear from the public?
Oh, sorry. I move that we close the public hearing.
Have a second?
Second.
All those in favor?
Aye.
Thank you both for being here.
I move resolution 2012-66.
Second?
I'll second.
All those in favor?
Aye.
Anyone
Aye.
against? So moved.
Good luck, gentlemen.
Resolution 2012-67, authorizing a tax refund pursuant to court orders and a tax certiorari proceedings.
I'll move it.
Is there a second?
I'll second.
Anyone against? So moved. Resolution 2012-68, approving the abstract award of claims.
I would still like Lise to question the lighting fee. It went up from July, August went up, it shouldn't go up. It's ridiculous. We pay less in the winter than we pay in the summer. I don't understand that.
The last time,
It was 10,000 something, and this time it's 11,000.
yet, we had changed providers. Maybe it's time for us to talk about
Changing providers.
changing providers once again.
Okay. Want to move that and subject to,
No, it's obviously the bill, it's just I think that, we should look for another provider. This one's becoming very expensive.
You know, they give us a low ball to begin with.
And then
And-
in
and
a year it
that-
goes up.
Right, so. Like people who shop for the telephone and television service, that bounce back and forth or to save a few dollars. We're just gonna have to do the same thing.
does someone want to move it?
Okay, I'll move resolution 2012-68. Resolved that the funds set forth on page 1 through 4 on an abstract dated August 16th, 2000, and, September, sorry. September 20th, 2012, has the wrong date. September 20th, 2012, in the aggregate amount of $160,434.09 be hereby approved.
I'll second.
All those in favor?
Aye.
Anyone against? So
Change
moved.
the date on the abstract. Ron, please. Mine says August.
That's the old.
This is-
Mine says August.
Look at the agenda.
Look at the bottom, look at the last page.
September 20th.
The bottom.
This one says.
Oh.
He didn't change the date.
That's what I'm saying, change the date.
Right, change the date. Gotcha.
Hey, this is a public part of the meeting. Anybody wants to speak on any project, anything, just 5-minute limits, but anybody can talk about whatever they want.
No one else wants to, I'll go first, but if someone else wants to, I spoke
Nobody else
already.
is making a move.
Good evening again, Richie Mitzner, 810 Chestnut Road. For the record, which brings me to my first comment and or complaint. I was always under the impression that when you said, for the record, it would be put in the record. I've been reviewing the minutes, and I know not everything is verbatim, but there are some striking examples of things that were said for the record that have been eliminated or just not included in the minutes. And if I'm wrong what for the record means, please let me know, because then I'll just start handing everything in pre-written if necessary. So I guess if we follow the same procedure we did before, someone will try to answer my question afterward.
Stop.
I'm stopping again. Still Richie?
Start the time over.
Still Richie Mitzner. Then that brings me to my next one, when I say, for the record doesn't do it, then attachments will. But I've also noticed, both the hard copy of minutes and what's online doesn't include things that I've handed in to the board as to be included as part of the minutes. Now, if I'm wrong, and that's not a requirement, I stand corrected, but I just need to know because I have these expectations. I do have a question that if I can get the answer before the end of all my comments, it'll make it a little easier. For minutes, for this board or for whatever board, by way of example, the minutes that are gonna be drawn up for tonight, next month or whatever month they come up for approval, is a quorum of the board required, of the people that were in attendance for the meeting that the minutes reflect, required to approve minutes? That's my question. And a quorum, I always thought, was if it's a 5-member board, it's 3 people. If it's a 9-member board, it's 5 people, etc. So I just need to know that to be able to intelligently continue.
I would think.
Maybe the village attorney?
I know for this
Yes.
board, if you're not present, we always abstain.
Yeah,
Okay. All right, and so you would need a quorum to approve this month's minutes. Because, let's say Sam
not
was
a
absent.
quorum, you need a majority
Majority.
of the persons who attended the meeting to approve the minutes.
Not a majority of the 5-man board?
A majority of the persons who attended the meeting to approve the minutes, because the minutes are approved by the people, as Joan just said. If a member was not present, they abstain, they don't vote for the minutes, unless they're gonna listen to the tape, then they can vote on the minutes.
Right, aside from listening to this tape,
Right.
just to see if I have it clear.
If 3 members were present at the August meeting, those 3 members have to vote on the minutes of that August meeting.
What happens if only 2 of them are in attendance tonight to vote on that meeting?
Well, then we would hope that somebody else would listen to
No,
the tape.
aside from listening to the tape, that's why I'm trying to get it clear. Let's say a 7-member board.
Yeah,
5 people were present for a hearing. The minutes are approved or brought up for approval the following month. The 2 members from the previous month are now here, but they haven't listened to the tape, so they can't vote. And 2 of the members that were at that meeting aren't here. So now there's only 3 members. Is that enough? Because there was only 5 the month before. There are 3. That's a majority of the 5, but it's not a majority of the board. Are those 3 enough to approve the minutes from a 7-member board?
no.
No, because they need at least 4 from the 7-member board. Okay, then we're on the same page. That being said, minutes from the zoning board, specifically, but not to exclude others. Last month at the ZBA meeting, minutes from the August 2011 ZBA meeting, that's a year prior, were brought up for approval. Richard Miller, Steve Liebman, Kathy Gallo said yes. There were only 3 people. It's a 7-member board. Given what Ms. Ullman just said, how could those minutes have been approved by a vote of 3 on a 7-member board? I say they can't. Given what Ms. Ullman said, she seems to agree with me. Also last month, the September 2011 minutes were brought up for approval, a year later. 11 months. Richard Miller, Kathy Gallo, Steve Liebman said yes. Again, only 3 members of the 7-member board. Now, I bring this up because I've been to zoning board hearings, and when only 4 members were in attendance and an applicant is there, the chairman correctly told the person, you need a majority of the board. And even though we're only 4, we're a 7-member board. So you need all 4 of our votes for your application. If it's right there, it's right here. So I ask you, and I'll get the answer later, how can we approve those ZBA minutes without at least 4 members from the board that attended them? And you can't even have people listen to the tape, because the people now that are on the board added to the board, only 4 of them.
5 minutes is
Oh, well,
Oh, my
really?
only question is, if the people who are on the board now were not on the board, when those minutes were where those meetings took place, then I'm not sure how it should go. In other words, if those were the only 3 members of the board remaining when those minutes were
They
done.
can always listen to the tape.
Yeah.
And that wasn't the case. There are other, they have a quorum, they just can't get a quorum together.
This is not good.
Bottom line is, it was done. I don't believe they've been legally approved. And anything that results, you build a building with a faulty foundation, that building's coming down now, no matter what kind of great job you did from floor up to the penthouse. If that foundation is faulty, the whole house falls down. And I think the zoning board's whole house fell down. Can I
Your time is up.
just say one statement? I had others, and I think part of it was Alman. I wish she had spoken faster, but,
You invited her into your time.
I know, and had she spoken faster, I wouldn't have understood anything. But I just want to put something on record, that as you know, Mr. Landscape's site plan has not been signed, and Biosphere's site plan has not been signed. And you would be remiss, if not something more stringent legally, if you were to rush that through to be signed while there's so many legal actions going on with another landscaper. I'm sorry, I only had 3 other things, but I will end.
Anyone else?
Yes. Mark Levine, 14 Lancaster Lane, Chestnut Ridge. Similar topic, minutes. When your board or any board votes on your minutes, it's basically your responsibility, to the best of your ability, to see that they reflect what happened at the meeting. As I review minutes, I find that they leave a lot to be desired as far as what has transpired at a meeting. I could go on, but because of the 5 minutes, I just want to briefly discuss some things that I find a little disturbing. What I'm going to show you here tonight is not a reflection, it's just a partial thing of what's going on and what I'm just trying to let you understand that you have a responsibility when you say, yes, I approve the minutes, that they have to be somewhat accurate. And what I'm presenting tonight isn't at all inclusive of everything. It would take me a tremendous amount of time, and I only have probably 3 minutes left. But when I reviewed the May 15, 2008 village board minutes. And at that meeting, there was discussions about a $90 million hotel project and different things happening in the village. You voted on minutes that didn't reflect anything at all on that $90 million project, was all removed from the minutes. And you approved it, each and every one of you. Okay. Thursday, October 15, 2009 minutes. You had a whole group of lands.
October what?
October 15, 2009. And then take back 15 seconds on that now.
Got it.
That was the meeting when all the landscapers came before you, were asking if they're grandfathered. There was a lot of discussion going on, and a lot of those discussions on grandfathering aren't in the written minutes. It's on video, it's on other documents, but it's not reflected in your minutes. What I found a little disturbing that actually brought me here tonight to speak about this was your August 15th, 2000 minutes. And the reason I got flagged on this, and I have to thank Mr. Burns, I'm sorry. Let me start over on this. November 17th, 2011 minutes. Forget what I just previously said of August 15, 2000. I'm referring to the November 17th, 2011 minutes. When I read your minutes, Mr. Burns stated, "I don't understand how our deputy planning board chairman advocates somebody's site plan, takes a position, admits on the record how much time he's spending on this matter, etc., etc." So I look back in the minutes to see what I said that upset him. And in your minutes, there's absolutely nothing here that could have possibly upset him. So then I started to think, what did I say at that meeting? And then I remembered. That was the meeting when I presented this document to you, Mr. Mayor, that was missing from the village files. The August 15th, 2000 minutes of CDRC, and I'm just going to do it to refresh your memory, that I stood up here saying how item 6 said CDRC believes the use as a landscaper is permitted in the yellow zone, and that when I went to the village files to get this document, because the zoning board didn't accept that one page, they wanted the full document, it was missing. Anyway, I stated all of this in the November 17, 2011 minutes. I'm sorry, at the November 17, 2011 meeting. It's not in the minutes. I also spoke about an application that the zoning board was hearing from the 30 Separ Lane neighbor, Chestnut Ridge Associates, where they stated they
Mark, your
owned
time is up.
the property. I understand that, Howie, but this is kind of important for your board.
Just conclude.
I am gonna
Thank
conclude, okay. So basically, I said a lot at that meeting. There's nothing in the minutes about what I said. And I can understand that the minutes are not verbatim, but it's all gone.
Doris?
And just let me, I'm gonna finalize, Howie.
You're
You
done.
voted on it.
All right, let's take up your question. Doris, are there any standards for minutes of a meeting? Is there a template that should be followed or is required to be followed in order to get every point, every word that is established into the meeting?
No.
Okay, so what is the requirement for minutes?
It's a board policy as to what it puts into its own minutes.
Now, what we've been following for last number of years, and we've had, with different people transcribing them over the years. What are the essentials that we put into it? People who spoke? Do we cover all the people who speak and trying to summarize what they say? Or do we have, I'm trying to address Mark's comment, to see how inclusive the minutes should be.
Normally, in order that minutes do not become 100-page documents for every single meeting, we try to summarize what was said as concisely as possible. Also, where if one person is cited in the minutes, we try to make sure that everybody else who spoke on the same subject is also cited in the minutes. But you won't find every single subject that was discussed in the minutes.
So in other words, it's a summary of what,
It's a summary of what happened at the meeting.
okay.
That
And if
doesn't
things
include
are,
everything that happened.
and if things are omitted from the minutes verbatim, in
All board
actuality-
resolutions, the minutes, state law says, minutes must contain all board actions, period. Many communities only have in their minutes the resolutions and local laws that are adopted by the board. This board has always gone beyond that and for historical purposes attempted to, without again having 100-page minutes at every meeting, try to cover most of the important things that are said by the public, by various people. Certainly in a public hearing, we have statements of every person who speaks. Not verbatim, but a summary of what that person said. But at a regular meeting, we've always tried to summarize as much as possible, putting in the most important issues that are raised.
All right, and now I remember when we first formed the village, that we were very upset with Ramapo's minutes from the ZBA, Planning Board, and Town Board meetings, where they just said, a resolution was presented, and it was accepted on a vote of 5-3, if I'm making up that number, but, and it didn't, if I recall correctly, it didn't even mention who voted for what, who voted for and who voted against it, and.
Our minutes are much more detailed, as you know,
Yeah,
all of our boards.
all right, so in essence, Mark, we've always fallen back on the tapes. If somebody was interested in the word-for-word transactions that took place, the tapes were always available. And the minutes reflect a summary of what took place. Will they include everything that you're looking for? Probably not.
Howie, I agree with you, except when it gets into sensitive topics, and the topics that I mentioned tonight and just brought up, the 3 little issues on 3 different minutes, were all specific, sensitive topics. And it's as if we're rewriting the story. Okay? I understand that minutes don't have to be verbatim. And in these minutes, if you recall, and I do recall, I had a discussion with you about a zoning board member. That's in the minutes. And that's as far as it goes. When I told the mayor that I'm giving him this document for the record, for safekeeping, that's not in the minutes. It's, doesn't have to be verbatim, I agree with you. And it could have just said, Mr. Levine discussed mincing paperwork and presented it to the mayor. Mr. Levine discussed an application that was presented to the zoning board that he thought wasn't appropriate. And that could have been the end of it. But everything, and I could be wrong, I mean, you could be editing Mr. Burns too, but it seemed like everything Mr. Burns said and other people said were pretty verbatim. And it's just a little insulting when I say, for the record, I want this on the record. And, you know, I'm bringing this information up, not to fight with the board, but to educate the board to some degree on what I feel is happening that's not appropriate. And to take it out in the minutes, that's any, you know, insult to injury here. I should have some kind of freedom of speech, and it's you're approving them. You're saying this is what happened, and it's not. And that's all I'm trying to tell you right now. Okay?
Oh, can I just get an answer or clarification to my 2 things? Whether for the record means what I think it means, and when I give something to be included with the minutes, be made part of the record, whether that's supposed to be made part of the record?
You had your 5.
No, well, maybe I'm being presumptuous. Mr. Presti last month had the courtesy that after I spoke, he would do his best he could. He did an excellent job of answering my questions.
In all the years that I've been with the board, I don't recall ever having addenda to village board minutes. It's never been the policy to have anything attached to the minutes. When something is given to the board for the record, it is kept by the village clerk as a public record.
What kind of file would I find it if I went in to ask for it?
I don't know how she keeps her
If-
files.
No, if it was given to me at a village board meeting pertaining to the minutes, I would put it in that folder.
She keeps a separate folder for every
Because
board meeting.
I've foiled minutes, and I was surprised that the documents,
They're
We've
not
never
attached.
attached them. From
Never
day one, the
so when I
village,
foil the minutes,
has
I should
never
ask for any
attached
other, and any paperwork that was, all right, now I learned. And when I say for the record, and it's a comment like Mark is saying, that doesn't mean the person has the expectation that it would be in the minutes?
It's on the tape.
it'll
Well,
be,
it's on the
it'll be in the public record.
All right, well, you do know there are foiled tapes that aren't available, so that,
No, all the tapes are available from the minutes.
I have foiled tapes from the ZBA
Oh, that I don't
that are
know.
not available. Well, I'm not picking on any
Right.
one particular thing. How he said, we've always gone back on the tapes, but they haven't been made available on a regular basis. I'm finished.
Thank you.
I'll move to close the public discussion.
I'll second.
All those in favor?
Aye.
Anyone against? So moved.
Move to adjourn.
All those in favor?
Aye.
Anyone against? Meeting adjourned.
Rankings, probably only 3 minutes of the first quarter. Don't say the score.
I
Maybe my son would have texted me on your T-bone. Oh, he's watching. Forget about recording. He's gonna record it. He recorded it for me last week. We ran out at 6 minutes and 27 seconds left of the game. That thing was tied, they scored 3 times.
That's when
That's when I missed it. I didn't have too much money on it.
I can't believe it.
How you doing?
I wish I could, believe me.
Florence,